What's up, everybody? We've got Scottie Scheffler's first court hearing streamed on YouTube. We're going to react and break it down together. One of the main focuses is treating Scottie Scheffler like everybody else. But are they? We break that down. We break if there's any indication as to whether or not there's going to be a deal or whether or not the state is going to push forward with these charges. Are we going to be surprised? I'm going to answer your questions, read your comments. Let's get into it. So this is the judge, and it's a hearing. Today, May 21st, was supposed to be the arraignment. At the arraignment, Scottie Scheffler, usually in felonies, and after watching this, I found out that Kentucky is like Florida, where usually felonies, the defendant has to show up unless there's some kind of hardship or reason that the judge allows him not to have to show up or to show up remotely or things like that, which we'll get into what they may allow or may not allow. Misdemeanors, usually with a written waiver of appearance, you don't have to show up. That's why, again, it's so important that he wasn't just charged with ticky-tack, civil citations or infractions or even misdemeanors, lower-level crimes. But he was charged with a felony, second-degree assault on a police officer, which creates all sorts of issues, right? If you're a convicted felon, you can't vote, you can't have firearms, all sorts of restrictions are put on you. Usually, if you're convicted of a felony and that goes on your record forever and you're dealing with this stuff for basically the rest of your life. Certain states won't expunge or seal felony convictions. Certain states won't even seal felony arrests sometimes, depending on the circumstances. So that's why it was so serious. And another thing that comes with a felony charge and arrest is you have to show up. And if you're not from there, you got to get back there. And as we know, he lives in Texas. This was in Kentucky. So we're going to hear arguments from his lawyer on the defense side, from the state in this case. We're going to hear from the judge. And everybody's kind of feelings immediately on this case and why it's kind of highlighted on their docket. For anybody that's new, I watch these videos on 1.5 speed. If you want to watch it on a lower speed, you can click this settings thing right here, click playback speed, and you can slow it down to 75 or half or as slow as you want to do it. I like it on 1.5 speed. It keeps the video moving. It keeps the highlights rolling. We get to react, and it doesn't take 3 hours for us to get through these videos.
Wherever you want.
It's up to you. You're the judge.
Yeah, well, you can all stand up here, or you can.
This is the order in which the motion is on. So we're here to address. We actually have a prosecutor who had on here with the need.
Okay.
And tell me when you're ready, Judge.
All right. So this is just an order. You're asking to remove to change the arraignment date from tomorrow until June 3rd. Is that correct?
That's correct.
So this was yesterday, May 20th. So the motion is very clearly and specifically to move the arraignment date from May 21st to about 2 weeks later on June 3rd. That's it. Not to waive his appearance, not any special treatment, just to move the arraignment date. And that's important. We're going to remember that when we start listening to the state's arguments, or the Commonwealth as it's referred to here again in Kentucky. We're used to that if anybody's watching the Karen Reed case.
Okay.
Judge, bond was posted. There's been no violations. June. One of the reasons I'm requesting move is I'm gathering additional information to provide the county. Obviously, the defendant is from out of town. Rather than bringing him in for the purposes of a short arraignment, I'd like to have all the potential discovery together and exculpatory evidence before the arraignment. I understand the county is says we have to follow proper procedures. That's why we're filing this motion and asking, Judge, I think per the rules, and again, I know that we're waiving the 3.10 that a continuance to June 3rd would be appropriate in this case.
Okay.
So the reason the defense, and this is interesting too, the reason the defense wants to continue the arraignment or to push it out 2 weeks is to gather exculpatory evidence, meaning evidence that proves Scottie Scheffler didn't commit a crime or is innocent, not the guy in other cases, but in this situation, just that his actions were not criminal. And they want to provide that to the state before the arraignment. Now, I'll tell you, the only reason we do that as lawyers is so that the charges are dropped before arraignment. Because if you're just trying to prove the case or you're trying to win the case or you're trying to work out a deal, you can do that after arraignment. Arraignment is just when Scottie Scheffler is officially charged and read the charges that are against him. So it's clear the defense wants to do that. But he mentioned something the state did. The state wanted us to follow proper protocols and procedures, so that's why we filed the motion. They could have potentially done this as an agreed order and just had the judge sign off on it, and the judge probably wouldn't have cared. But they didn't, because the state wants them to follow proper procedure. So is the state playing hardball, or are they trying to publicly have an a showing of we're treating him like everybody else, and they don't want to make it look like he's getting special treatment by continuing his arraignment and dropping the charges before Scottie Scheffler is ever arraigned. There's kind of two ways to look at this, and we'll see what other context we get throughout the rest of the hearing.
Okay, go ahead.
Judge, are you aware of the nature of this case?
I certainly am. I'm aware of the nature of the case. I am not a golfer, and I couldn't pick out two golfers on the
Okay,
planet,
I-
but I'm aware of the
I don't know if
nature.
Pretty much nobody can pick out two golfers. They look like regular guys, but now people can probably pick out Scottie Scheffler. She says she knows who the case is, and this is kind of that umbrella over this whole hearing is everybody wants to make sure it's like, listen, we realize who Scottie Scheffler is, but we're going to treat him like everybody else. Let's make sure this is fair, put him through the process like everybody else. But do they actually do that?
You were out of town over the
I
last
am
week
aware.
or something? But, yeah.
No, I'm aware.
So Judge, Michael Connell on behalf of the Commonwealth, and I've been trying to think of the best way to express this to you in response to Mr. Roman's motion, and I won't call him Steve in open court, but we've had communications as he's had with other members of the staff.
I won't call him Steve in open court, but we've had conversations with Steve. So they're friends is what that indicates to me, and friendly working together. It gets a little adversarial later, so stay tuned.
The status of this matter, underlying facts perhaps that may or may not be in dispute, et cetera. But we're here today to talk about an arraignment that is currently scheduled tomorrow in this court. Scottie Scheffler is not a name that a lot of people would know, perhaps they didn't follow the sport, but it's not a name that is not widely known literally around the world. Okay, he's from Dallas, Fort Worth, Texas. He came up here to play in the PGA Championship. This incident occurred on Friday morning that gave rise to why we're standing in front of you here today. There's an arraignment that's scheduled tomorrow here. I think, and wherever I'm wrong, Mr. Roman's going to interrupt me. I think he left last night after the tournament concluded. He flies by private jet back to his home. And is it Fort Worth or Dallas? You know, which one?
Judge, if he needs to be here, I'll have him here. No, this is, again, I assisted in arraigning or getting him out and getting his bond.
So what did the prosecutor say? He left. Yet we all know he left yesterday after the tournament. So there are things with this case that obviously we as golf fans know that maybe the judge doesn't know or people don't know. They come, they play. If they make the weekend, they play Thursday, Friday, Saturday, Sunday. After Sunday, he didn't win. He leaves and he flies by private jet is what he said. So throughout this hearing, there's two things that the prosecutor seems annoyed at. Why did he have to leave yesterday? Well, some people know he's got a wife and a newborn and a life back in Texas. And usually you ask your lawyer, so I don't know, but I'm guessing that Mr. Romine told him, sure, you can go home. But to say he flies by private jet, to me, is the first indication the Commonwealth is not treating him like anybody else. Because if he was anybody else and you were a normal person and you got arrested on a Friday night and were here for the weekend and you had a flight out Sunday, it costs money to change. And if you had to go back for your job on Monday, it'd be really hard to show up for a arraignment on Tuesday. And would the Commonwealth really force somebody to fly back from Texas on something like this that they released on their own recognizance? Now, I could say yes and no to that. Yes, if they really assaulted a police officer. No, if they were released in 5 seconds and treated like Scottie Scheffler was throughout the process, not really like a violent criminal. I don't think they would make him fly back. I actually think they'd get a remote appearance if they were from out of state. We've had that happen in Florida all the time. If they're from out of state and they have a lawyer and they're represented by private counsel and we're explaining to them the process, why make them fly back except to punish them, right? So he's got a private jet he mentions, and I get it. Boo-hoo, people with private jets. I'm not going to feel bad for them. Obviously, he could fly back right now anytime he wants. He's got the money. It's not going to hurt anything. But I mean, people say that's bad for the environment. I don't know. I'm not an expert in that. But why do that but to punish Scottie Scheffler, to make him show up to hear the charges against him when there are other things in the law? There are other ways to handle this when there are issues in the law. It's not special treatment for Scottie Scheffler. It's literally written into the law. You can continue an arraignment until it's more convenient for the lawyer and the defendant, or under certain circumstances, they can appear remotely. What circumstances? Usually when they're out of town. And I think having a wife with a newborn and already being gone for however many days is a pretty good argument for that. But they don't even push for that on Scottie Scheffler's side. He's like, is it Dallas or Fort Worth? He looks, and I don't think Romine wants to play nice on this, the defense lawyer. He's like, Judge, if we need to have him here, I'll have him here. That's not the problem. That's not the problem. He's conflating the issues. Never in our motion, and the judge even said in the beginning, the motion did not ask for Scottie Scheffler to not have to appear. It just asked to continue the arraignment hearing. So the Commonwealth is conflating two issues, making it seem like the defense doesn't want Scottie Scheffler to have to show up, but that's not what they're asking for.
That I was not present when the arraignment date was, and I assisted in arraigning or getting him out, and getting his bond set. I was not present when the arraignment date was set. As the court's aware, attorneys oftentimes are present when arraignments are set. That way, calendars and that type of thing can be coordinated. I was not. I'm asking, the arraignment date was given when the bond was posted. I'm asking to continue the arraignment to June 3rd.
This is 100% yes every time. Just spoiler alert. If your lawyer wasn't consulted on the arraignment date, the defendant wasn't consulted, the defendant's from out of town, all you're asking for is to continue it 2 weeks, Judge, so it works better on my calendar, the defendant's calendar. Let's get it set. I'm pretty sure the Commonwealth's going to be here because they're always here. Let's just set it on June 3rd. That's all we're asking for. This should be a slam dunk, easy yes. The prosecutors shouldn't have even argued with it. But it seems like they really want to make it apparent that they're trying to treat Scottie Scheffler like everybody else, when in my opinion, anybody else, this would have been an immediate yes. So it's really interesting to see how it's kind of going right off the jump. Prosecutors playing hardball a little bit, and it can either be posturing to make it seem like, see, we didn't go easy on him if they drop all the charges, or maybe they're going full bore. And it's still kind of an open question at this point. But the reason for this, just in case you're wondering, is if we got to show up for it, the courts are considerate of attorneys and criminal defendants, especially ones released on their own recognizance that aren't sitting in jail. If you're sitting in jail, obviously you want the arraignment to be like that for obvious reasons. But in this situation, if we're like, Judge, and I kind of think if Romine would have started with that argument instead of, we want to provide the Commonwealth with exculpatory evidence, now it kind of seems like he's trying to use this 2 weeks to argue the case to get the charges dropped, which is not inappropriate. But I think a slam dunk winning argument is, Judge, I was there to help him get out of jail. They didn't ask me about the arraignment date. We didn't schedule calendars with myself or Mr. Scheffler. That's all we want to do here. I think the judge would say yes 100 times out of 100 to that argument.
Bond conditions.
And I'm responding to that
Okay.
motion.
Okay.
Okay. The rule says, as you are well aware, that if you're charged with a felony, you are to be present for arraignment and in all stages of the proceeding. If you're charged with a misdemeanor, that's not the case. Your lawyer can come in and represent you and do many things. That's not the case with felony. Now,
but nowhere in the motion did he try to waive Scottie Scheffler's appearance. So I don't know if he read the motion wrong, if he just assumed that was the argument. I don't know if also these two lawyers had other conversations where maybe Mr. Romine said, maybe we'll waive his appearance as well, and that's what the Commonwealth is arguing, but that doesn't seem to be the question in front of the court at all.
there are instances where, and I'm going to show you language from the Kentucky Supreme Court. There are instances where, when appropriate.
Get ready to hear those words a lot. When appropriate, which frankly just means judicial discretion. The judge can determine when something's appropriate, even if she wants to waive Scottie Scheffler's appearance or allow him to appear by Zoom, which like the world does today. And the only reason to make criminal defendants show up is if you don't think they're going to show up, if you think they're going to disappear, which is also part of the bond requirements of why we do this, to make sure they don't just show up, leave or flee or commit other crimes if they're a danger to the community. But in a lot of situations, Zoom is fine. And it happens all the time still with our clients right now who aren't named Scottie Scheffler. All the time. Even though it seems like Florida has similar rules. You can even take a plea in absentia where you're in another state working or whatever, and you're taking a plea deal and getting, convicted with this. But when appropriate, the Commonwealth is going to make seem like you're giving him special treatment, Judge, and it's on you if you're going to let him waive his appearance, which the defense is not asking for.
This is an update from the Chief Justice back in March of 22. I've highlighted what it says.
And watch Romine's body language. I'm not a big body language guy, but he certainly seems frustrated, the defense attorney.
When appropriate, under the right set of circumstances, when appropriate, the defendant may be dealt with
remotely.
remote would be the word. Okay.
Okay.
I do not think this is a case where it is appropriate. I do not think this is a case that the defendant will be somehow put out, inconvenienced maybe for a short few hours, where he can be in and out of the bureau. But I do think it is appropriate that he be present with Mr. Romine and at the arraignment, where obviously a plea and not guilty will be entered. And then we have not had the opportunity, obviously yet, to review a lot of evidence that's out there. And I think we would agree that there's a lot of evidence out there. Much of it will be agreed upon, but some of it will not. But back to this situation.
Does it sound like he's treating Scottie Scheffler like everyone else? Within just mere hours, Judge, he can be here again because he has a private jet. Would he say that about anybody else? about your average citizen who lives in Texas and is charged with a crime in Kentucky? I don't know. Maybe he would. I don't know.
I think it's appropriate that he be here before the court to undergo an arraignment in your presence, and then let's pass the case and see where it goes from there.
He didn't say anything about the date, by the way. His best argument is about Scottie Scheffler appearing, which the defense hasn't argued with, but he hasn't said anything about moving the date yet. He will, but he hasn't yet.
And what occurs. I don't make this objection lightly. I make it very seriously. One of the tendered orders, I don't know if that he's given you refers to local rule of the district court. I know of no local rule.
Maybe I'm confused. I feel like he's just asking to move the arraignment, not to make his client
Correct.
not here.
Me too, Judge. Me too.
So is that, you're
That's
just
correct,
asking
Judge. If
to move it,
we
not
haven't resolved the case by June 3rd, he'll be here with me in court.
So there's an indication of where this case might be going. If we haven't resolved this case by June 3rd, meaning 2 weeks to resolve a case, which happens all the time. We resolve cases in 2 weeks all the time, especially when charges are dropped. So that's nothing crazy. So if we don't resolve this case by June 3rd, he will be here. His lawyer's saying it. I assume, has already talked to Scottie Scheffler. He'll fly his private jet up 2 weeks from now if they can't resolve the case. But they're gathering exculpatory evidence to pass it off to the state to try to resolve things before June 3rd. Now, 2 things can happen by June 3rd. Really only 2 things. He's not going to plead to a second-degree felony. No shot. So one of 2 things is going to happen if they resolve this case by June 3rd. Either one, all charges are dropped, and maybe even an apology. Or number 2, Scottie Scheffler pleads guilty or no contest to some civil infraction and pays a fine. Those are really the only 2 options I could see. I would be shocked even if he pled to a misdemeanor. It's possible, obviously, anything's possible, but if the lawyer's acting like this and what we know about the case thus far, my opinion would be only one of 2 things is going to happen if this case resolves by June 3rd, charges dropped or a civil infraction that he pays a fine.
That's
so again, he's just asking to move the arraignment, not to waive his presence. Is that correct?
yeah, that's the order.
Well, and I object. I think we need to get the arraignment done, and then let's begin the process of trying to see when and if this matter can be resolved.
So he says, I object. I object to even moving the date. So now we're going to switch arguments. We've wasted half the hearing on waiving presence, which wasn't an issue. So now let's get to the date. Why is the date a big deal to the Commonwealth? Why do they care if it's May 21st or June 3rd? And this is the type of stuff that is frustrating sometimes. And we don't always watch arraignment or hearings like this, but prosecutors have so much power and law enforcement has so much power. Like, imagine if you were a normal person, you had to buy another plane ticket, miss 2 more days of work, miss 2 more days with your wife and newborn just to show up so the court can say something you already know that your lawyer's already explained to you. As opposed to a more convenient date for you to fly up, plan it, whatever, take off work. If you're a normal person, I mean, this is a life ruiner. You might get fired if you've been charged with a felony like this, even if the charges get dropped, but that's neither here nor there. But the state can just say, no, I object. You got to show up on the 21st. Even though, again, this quick turnaround is usually so people don't sit in jail for a long time not knowing what they're charged with. It's not meant for situations like this. That's why we have these exceptions in the rules.
Prior to the next court date, and not move the arraignment out, and then expect at the time of the arraignment, whatever is expected, that something is going to happen. There's going to be a significant steps at that time. So it's not. This man should be treated like everyone else in this matter. Okay.
I couldn't agree more.
Okay.
But how,
She's like, I couldn't agree more. And Romine's like, yes, he should. And guess what? We do this all the time where we push arraignments 2 weeks. Big deal. It's a right of the defendant to be arraigned quickly. Like, come on. What are you talking about? And it's like, he doesn't want to admit, the state doesn't want to admit that something might happen by June 3rd, but instead arraign him. And then say, I don't really know why that's a difference, but I don't get, and the judge is going to ask some great questions here that's going to shine even more light on this.
The Supreme Court has said when appropriate. So, Judge, if you believe that it is appropriate to grant this motion, I respect that. But that's the criteria. It's not just, well, we ask and it gets pushed out to whenever it gets pushed out. It's when it's appropriate.
how would the county be prejudiced in any way?
Did you see Romine's face at the end of that? Watch the defense lawyer's face at the end. He's like, because he's got an argument here where, again, the Commonwealth is just missing the boat. And the judge asks a very important question right here. How does it hurt you, Mr. State? How does it hurt you if we push this 2 weeks? It's very difficult for Mr. Romine and Mr. Scheffler to do it tomorrow. So a common courtesy, give them 2 weeks. How does it hurt the state to push it 2 weeks? The answer is it doesn't at all.
get pushed out to whenever it gets pushed out. It's when it's appropriate.
How would the county be prejudiced in any way if we move? I'm not asking. So I've thought about this, and I'm going to require the defendant to be present unless somehow there is an agreement made before court, and then I will still rule on it. But I will rule upon whether or not, at this point, if you're asking me if the defendant must be present, my answer is yes.
So she's already said he's going to have to be present, treated like everybody else. Fine. If he's going to be present in another state, at least have the common courtesy to let him plan when to come, right? The guy's got no priors. He's been released on his own recognizance. He's been charged with a serious felony. So I get it. Make him show up in person. That's fine. I still think a lot of people wouldn't have to under the same circumstances if their name wasn't Scottie Scheffler. I think it kind of works both ways. But that's not even what we're here about. Why can we not push it?
Okay. I believe that the motion that Mr. Romans has on today is to move the arraignment. How will the county be prejudiced in any of its anything if the arraignment is moved?
Judge, I don't think it's a question of prejudice. It's not an issue. It's when appropriate.
That means no, we're not going to be prejudiced. And for the 100th time, he keeps saying when appropriate. And just wait till that argument gets blown out of the water. And then you'll be even more, face palm when you hear this phrase that he keeps using of when appropriate doesn't even apply to what we're talking about.
How
Is this defendant to be allowed to appear at some other distant date for whatever reason, or apparently his arraignment and something else that may or may not occur on that date?
So just that something else that he's referencing is potentially a disposition, meaning the case is over. So he's using these vague phrases that still lead me to believe it's possible that this case is done and charges are dropped, or again, he pleads to something very minor by June 3rd. So we want to have his arraignment and something else maybe on June 3rd, which leads me to believe, and it would not be uncommon or inappropriate at all if the defense lawyer and the prosecutor have already talked. We handle cases pre-charge all the time where we can, I talk about it all the time in these videos, that defense lawyers can get in there. They can affect what charges you're charged with. They can get plea deals done quick. They can provide you with information or witnesses that may make you drop the charges or think twice about filing or filing a different charge than you were planning on filing. So it's not inappropriate. We do it all the time if we know about a case before charges have been filed and before the defendant's been arraigned. But he says that something else. I'll back it up so you can hear it again. But arraignment and something else, whatever that may be.
To be allowed to appear at some other distant date for whatever reason, or apparently his arraignment and something else that may or may not occur on that date, I don't think that overcomes the when appropriate requirement that is required by our Kentucky Supreme Court.
So whenever I have
Omine wanted to jump in there, and he's got something very important to say, so just wait.
aside something as a summons, or whenever I set arraignment dates, I usually ask if the person is represented by counsel, something that's convenient for their calendar. Additionally, if they don't even have counsel, I'll ask the defendant sitting in my jury box, when is appropriate for them to come back? I'm not, so I pick an arraignment date, whatever's convenient for the court's calendar and the defendant and or an attorney if represented. So I do that every single person that comes before me. So I try to.
Everybody wants to make sure people know they're not giving Scottie Scheffler any special treatment. And nobody wants to be accused of that. Nobody. The defendant's attorney hasn't said anything, but between the Commonwealth and the judge, they keep saying, I don't know who he is. He should be treated like everybody else. I do this for everybody else because nobody wants to be accused of special treatment. And I got to be honest, it almost feels like it's going the other way. Sometimes it's better to be an average Joe. Obviously, just generally in life, it's better to be Scottie Scheffler. I'm not saying that. But they want to make sure so much that the Commonwealth won't even give him the same common courtesy they give to, John Smith.
Make it convenient for people's calendars if they have other things going on. So if you'll just make me aware of how it prejudices the county if I do grant, and again, my order as of this moment, unless brought before me again, and that's not what Mr. Romans is asking me.
Correct.
Mr. Romans is asking me to move the arraignment date, not waive his presence. So at this time, again, I'm not waiving his presence. I am wondering why the county is objecting to his arraignment being on June 3rd rather than May 21st, if that's more convenient for Mr. Romans' calendar.
And again, the state is saying prejudice is not the question, and they may be right, but prejudice is always a question because in our justice system, the interests of justice prevail. So it wouldn't be fair if this was a major prejudice to the Commonwealth, which I think the judge is right to ask that. If they would have said, we have everything, we need to go right now, we've got a trial on June 3rd, and I'm handling this case and that case, this was already scheduled, we lined up people to, I don't know. If they had some argument that it would prejudice them to move it, then I think the judge would consider it in the interest of justice, even though this when appropriate standard that he's trying to apply to moving the date is not the same thing as prejudice.
We think that is how the matter should be processed. It was set for this date. Mr. Scheffler, as we all know, was here for 6 days or however many days.
I don't know how
Well,
long
he
Mr.
was here, he
Scheffler
played
was
in
here.
the tournament, Judge, and he left last night
Okay.
and returned home in doubt.
He's like, everybody knows how long he was here. Also weird and not something you would know about your average Joe, but of course he knows about Scottie Scheffler. And the judge is like, I don't know how long he was here. It seems like he's mad that he left the day before his arraignment or 2 days before.
Okay. The standard is when appropriate, not whether we all agree about it. We all think it's a good idea. It all sounds good. It's when and if it's appropriate. And respectfully,
Romine is so frustrated. He's like, I got to jump in here, Judge.
well, does not think that this is appropriate to do that. So we don't have an agreement, Judge, and I don't think we're required to show prejudice. It's when appropriate.
Judge, this is an adversarial system. They're on one side, I'm on the other. I made the motion. They're objecting. He keeps referring to when appropriate, which is specifically referring to remote appearance. There's nothing about inappropriate regarding moving a court date. It happens.
What? Like the whole time he's been arguing the standard when appropriate, which only has to do with remote appearance. The judge even finishes the defense lawyer's argument for him. The judge agrees and knew it. That's why she's asking the prejudice. She's not asking what's appropriate, because that when appropriate standard is only for waiving your appearance and to appear by Zoom or remotely somehow by phone. It has nothing to do with moving the court date, which is all this motion and hearing was about. So the Commonwealth for the last 11 minutes has been arguing the wrong argument still under the wrong standard. When appropriate does not apply to moving the court date here in this language, according to the defense lawyer and the judge. How frustrated would you be if you were the defense attorney in this case? Listen to it one more time. I mean, he wanted to jump in so bad.
And I don't
Side on the other. I made the motion. They're objecting. He keeps referring to when appropriate, which is specifically referring to remote appearance. There's nothing about inappropriate regarding moving a court date. It happens every day. And so if Mr. O'Connell says, well, we don't want to treat him differently, then go through and look how many cases are agreed to by continuance by the county every day. They are absolutely treating him differently, right? And they have no basis for it. He keeps referring to when appropriate. That language does not refer to motions to continue. It refers to remote appearance. And we're not asking for that, Judge.
I agree with that. But the word speaker.
I mean, that was a good little, and he wanted it. He wanted to get out. He wanted to go. And finally he went.
Himself, Judge. It says when appropriate. Okay. Those are normal words used under circumstances, and it talks about remote availability to do it. When appropriate. Mr. Romine thinks it's plenty appropriate that this be continued to another date rather than the date it was scheduled for. I disagree. So, Judge, you make the decision. We obviously respect the decision you make in this regard, and we'll follow whatever directions you issue, but we object.
Okay. Mr. Romans, was your calendar consulted at the time when the
No,
arrangement
no,
was set?
he
Okay.
was not actually in court. His bond was set. He was released. And so they did not consult me regarding that date.
Okay. So again, let me be very clear. And I feel like you all still are arguing about different things. But again, my ruling is number one, his presence is not waived. He needs to be present at the court date. That is my decision. Even if you all agree, it's still my decision whether or not he's here. If you all come to an agreement to waive his presence, I will rule upon that at a later time, and you can bring that in front of me. My understanding and what the written motion in front of me is only to move the arraignment date, not waive his presence.
Correct.
I feel that since Mr. Romine's calendar was not consulted and he was already representing the defendant, that it would be appropriate to consult his calendar for the arraignment. So I will move the arraignment to June 3rd at 9:00 in the morning. And again, at this time, your client's presence
Correct,
is not
Judge.
waived.
That's understood.
Judge, thank you very much.
Thank you,
Thank you. Of course. Thank you.
You're not excused,
Of
Judge.
course.
We have happy to. Judge. I don't want you not to excuse him and not excuse
You're
him.
certainly.
So yeah, no surprise. She continues it to June 3rd, but that big of a fight to move the arraignment from May 21st to June 3rd is wild to me. So there is a piece of me and a part of me that wonders, are they going to fight this case hard? Or was this kind of his one shining moment to show he's not going to treat Scottie Scheffler any easier or nicer than anybody else? Did Romine know they were going to come do this big argument that people would look at and break down and say, oh, they're really playing hardball with Scottie Scheffler? I don't know. I could see it going either way. And if all this stuff is resolved by June 3rd, this motion is going to look a lot worse. This hearing is going to look a lot worse for the Commonwealth, in my opinion, because even worse, like you dropped the charges a week later and you were going to make this guy fly up the next day to sit in court for 5 minutes to hear the charges read to him that his lawyers already explained. I don't get it. That's just like using your power to punish people that you're going to drop charges for later, which is if he committed a crime, prosecute him, try the case, convict him, do it the right way. If he committed a crime. If not, what are we doing? Like, what are we doing? I don't get it. But all right, let me know what you guys think in the comments. I love reading the comments on these videos because it's really interesting to hear everybody's different take. A lot of people, see this from different ways. And a lot of people want Scottie Scheffler to be treated like everybody else, as do I. I want him to be treated like everybody else who has a clean record, has a positive reputation in the community, was there for an appropriate reason. And by the way, you can't really treat him like everybody else because who he was mattered at the time of the crime. He was in a marked vehicle, driving somewhere he was supposed to be, getting special treatment, just like all the other players, to be able to drive and go in different areas that you or I might not have been able to do at the time. So he can't really be treated like everybody else because he had different rules and responsibilities that day than other people did. So we've got to take that into account as well. And that's how I'm looking at the case. So you guys let me know. I'll read through them. Hit that like button if you haven't already, and make sure you subscribe to our page. That's all I got. Till next time, I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a pase you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.